Hi, my name is Yogya Bhatia and I am a legal intern at LEXIS and Company. Today, I'll be talking about power of attorney and its revocation. If for some reason a person is unable to execute a document himself, he may authorize a third party to execute such document on his behalf by mode of granting the said third party. Power of attorney, it is regulated by the Power of Attorney Act 1892 and other relevant laws in India. A power of attorney may be a general power of attorney if the principal grants the power of attorney holder all such powers which are necessary to accomplish the object for which such power of attorney is given. Special power of attorney if the principal wants the power of attorney holder to exercise only such powers as are specified in the power of attorney deed. It is important to know the procedure and legalities involved in revocation once power of attorney is granted to an agent to avoid any misuse of power. Kinds of power of attorney. Power of attorney, depending upon the clause of the deed executed, may be revocable if the power of attorney is revocable at the will of the principal, irrevocable if the power of attorney is not revocable at the will of the principal. Revocable power of attorney. Generally, the principal has a right to terminate the power of attorney whenever he wills to do so. Some of the conditions for revocations are if the principal revokes the power of attorney granted to the agent, if either the principal or the power of attorney holder or both become unsound mind, die, or are educated or insolvent by the court, if the person of attorney holder renounces his powers, if the business for which the power of attorney was granted gets completed. Power of attorney may also be revoked if there is an implied revocation of the power of attorney or in case of time barred agency, the term of the power of attorney expires. Irrevocable power of attorney. A power of attorney may have a clause in it stating that such power of attorney is irrevocable. A power of attorney shall not be deemed to be an irrevocable one merely because it states, in the clause of the deed, executed for grant of such power of attorney, or if being irrevocable. Such power of attorney may be revoked by the principal or the power of attorney holder by the procedure according to the law. For revocation of irrevocable power of attorney, the principal is required to issue a public notice through local newspaper, without which the revocation shall stand void. However, in the following case, a principal cannot revoke a power of attorney where the power of attorney holder, that is the agent himself, has an interest in the subject matter of the power of attorney. For revocation of the power of attorney falling under this category, consent of the power of attorney holder is mandatory. Where the agent has partly exercised the act for which power of attorney is granted, he cannot be stripped with the right for the act which he is already exercised. Section 202 of the Indian Contract Act and revocation of power of attorney. Section 202 of the Indian Contract Act 1872 reads, where the agent has himself an interest in the property which forms the subject matter of the agency cannot, in the absence of an express contract, be terminated to the prejudice of such interest. Therefore, by virtue of this section, a power of attorney cannot be revoked by the principal without the consent of the agent if the agent has an interest in the subject matter of the power of attorney. Moreover, such power of attorney is not deemed to revoke even after death or insanity of the principal. To understand situations where the power of attorney can be said to be coupled, the following cases may be referred to. The Supreme Court of India in Seth Lun Karan Setia vs. Ivan E. John held that agency cannot be revoked where such agency is created in exchange for some valuable consideration and the authority granted by the agency is to secure the interest of the agent or to effectuate the security against such consideration. Therefore, in case where the agent himself has an interest in the property, the agency cannot be terminated unless there is an express contract for such termination to the prejudice of the agency holder. In another case, Vishnu Charya vs. Ramchandra, the agent used to get his salary out of the rent collected by him on behalf of the principal. The agency which authorized the agent to collect rent was held to be not coupled with interest. Therefore, where the agency merely grants some remuneration or commission, it cannot be held be an agency coupled with interest. Revoking power of attorney. Some of the important things to know about the revocation of power of attorney are notice. In an express revocation of power of attorney, whoever, whether the principal or the agent, requires to end the power of attorney must give reasonable notice to the party before the revocation. Upon failure to do so, all cause of damages caused on account of such failure incurred by the other party to whom such notice was owed shall be made good by the party who failed to fulfill his obligation to give such notice. Reasonability of the notice differs from case to case depending upon the clause of the deed. An implied revocation does not require a prior notice. Unregistered power of attorney, registered power of attorney. A power of attorney may be registered or unregistered. The procedure for revocation of both of them are different. For registered, a registered power of attorney can only be revoked by means of a registered deed. Unregistered, an unregistered power of attorney can only be revoked by an unregistered instrument of revocation. Apart from that, it is required to issue a public notice regarding such revocation through local newspapers, without which the revocation shall stand void. When the power of attorney is executed jointly, if the power of attorney is executed jointly by several people, it is not valid for one of the principals to effectuate the revocation of the agent without the consent of the others. However, if the joint execution is executed severally, revocation by one of the principals of the agent is valid.